Good morning, Your Honor. This is Theodore Leal, Spanish interpreter. The interpreter has been previously sworn, Your Honor.
Good, thank you. Good morning. If you could please connect with the headset.
Thank you, Your Honor.
Sí,
Interpreter is connected to the podium, Your Honor. Thank you.
Sir, please tell me your name.
Félix Emmanuel Hiraldo.
Felix Manuel Hiraldo.
21 MM 617. You're here charged with battery domestic violence. There is probable cause. I'll appoint an attorney to represent you. Does the state object to pretrial release in this case?
No, Your Honor, but state would ask for bond due to the victim not being able to hear today.
Permiso, yo nunca he tenido este tipo de problemas y no sé ni qué pasa en realidad, no sé qué pasaría, ni sé, ni en realidad no creo que haya sido un motivo de que me hayan traído acá porque yo nunca he agredido a nadie.
Excuse me. I've never been involved in this kind of problem, and I really don't understand quite well what's going on, to tell you the truth. And the truth is that I don't know why I was brought in here, because I did not commit any act of aggression against anyone, so I don't know.
All right, sir. I'm going to ask the state to put the factual basis on the record.
On or about September 21st of 2021 in Orange County, Florida, law enforcement was dispatched to 11144 Ledgement Lane and spoke to Christina Marie Pina Acosta.
Never mind, go ahead.
She advised law enforcement that Felix called her phone and became verbally aggressive towards her and told her he was not going to give her car back and would drive it into a lake. When he arrived back home in the car, she told him she was going to call 911, at which point he tried to grab the cell phone from her that was in her hand. They struggled over the cell phone, resulting in him either grabbing her forearm or hitting her with his hand on her forearm. She later stated that they've been throwing clothes at each other all day. There was also an independent witness, Mr. Javier.
Excuse me, counsel. I'm sorry, Your Honor, just to remind counsel that the interpreter is trying to catch up and interpreting simultaneously, but that's too fast.
Okay, thank you.
I don't know where he finished. I was done.
Well, that was the factual basis for the battery.
Grab the forearmed, and then after that, the very last idea, the last, I think was 2 sentences.
Grabbed her forearm or hit her with his hand, and then eventually started throwing clothes at one another until he came home. There was also an independent witness, Mr. Villanova. All events occurred in Orange County, Florida.
Thank you.
So that's the factual basis, sir. That's why you were arrested and brought to jail. I reviewed the probable cause affidavit that was written by law enforcement. I determined there is probable cause for your arrest. I'm going to place you on pretrial release and require that you post a monetary bond of $100. With special conditions, you can have no contact with the victim. Do you understand what no contact means?
Yes.
You cannot possess or consume, you cannot possess a weapon of any kind, firearm, or ammunition. Were you living with her?
Yes.
You cannot now. I'll order you must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings. You also cannot have contact with any witness in this case. Good luck, sir. Sir, please tell me your name.
Denis Morales.
Denis Morales.
2017 CF 10051. You're here for a violation of probation. I'm going to appoint an attorney to represent you. The allegation is that while on probation, you committed the criminal offense of knowingly driving with a suspended license, giving a false identification to law enforcement, changing your residence without permission, using intoxicants to excess, 2 counts of that.
Yo no cambié mi dirección sin permiso.
I did not change my address without permission.
It sounds like you think you have a defense, but you're going to have to present that to the judge who placed you on probation.
Okay, porque yo fui,
Okay.
yo cuando yo fui a la última cita de mi probatoria, ella me dijo a mí que era mi última cita y que ya yo no tenía que volver para allá para nada, para mi probatoria. Y ahí fue que yo me decidí mudarme de aquí de Orlando porque fue que yo cometí mi primer error. Y yo decidí.
Well, the thing is that when I had my appointment with the probation officer, I attended my last appointment, and she told me back then that that was my last appointment, that I didn't have to go back anymore. And it was at around that time that I did move. I decided to move out of Orlando because I had made a mistake, my first mistake that I made here.
Well, sir, again, that's something you're going to have to present in front of the judge who placed you on probation. There's no bond authorized on this warrant at this time, so make sure that you get in touch with your attorney right away so they can present any defenses that you have. Good luck, sir. Please tell me your name.
Cristal Aquino González.
Cristal Aquino Gonzalez.
This is 21 CF 12625. You're here charged with burglary of a conveyance with assault or battery. I'm going to appoint an attorney to represent you in this case. There is probable cause here. Ms. May, did the state wish to be heard?
Yes, Your Honor. Given that she is charged with a life offense, they would ask that you hold her no bond pending an Arthur hearing.
All right, Mr. Brands.
Argument, Your Honor, pending the Arthur hearing with her attorney.
I will do that. Ma'am, this is a first-degree felony punishable by life in prison. So at this time, you'll have no bond. However, even while in custody, you can have no contact with the victim or any witness in this case. Do you understand what no contact means?
Sí, pero ahora mismo no hubo ni tan siquiera contacto físico porque habían cámaras presentes y yo pedí que viera las cámaras y el guardia se negó. Porque ahora mismo la policía se llamó nada más por un accidente, no por ninguna agresión.
Yes, but the thing is, there was no type of physical contact whatsoever, and actually there were cameras there, and I requested from the guard that was there so as we could see the information caught by the cameras, and he refused to do so, and there was no type of aggression whatsoever.
Ma'am, it sounds like you think that you have some defenses. You need to get in touch with your attorney right away so you can raise those defenses. However, you'll not be doing that today. We're not having an evidentiary hearing. The only thing we're here for today is probable cause. At this time, I'm also revoking your out-on-bond cases, 21 CF 12024 and 20 MM 2844. Stay in touch with your attorney, ma'am.
Ok, ven acá, so, no tengo fianza hoy para nada.
So I have no type of bond today whatsoever.
That is correct.
So, tengo que quedarme aquí hasta qué día.
So I have to stay here till when?
Your attorney is going to have to file a motion in front of the trial judge.
Ahora mismo yo tengo cáncer, yo no puedo estar con mucha gente, so yo no puedo estar aquí.
Well, right now I have cancer and I cannot be here with so many people.
I'm sorry, ma'am. That's going to be something you need to discuss with your attorney and ask them to file a motion to change your bond. But at this time, you have no bond.
So, ahora mismo yo puedo llamar a mi abogado y eso puede cambiar hoy.
So can I call my lawyer today and have things changed today?
It will not be changed today because your attorney's going to have to file a motion in front of the trial judge. They have to give notice to the state attorney because the state has to bring witnesses and you have the right to bring witnesses to that hearing if you so desire. But the reason I revoked your bond in those two cases is you were out on bond for violent offenses and you were arrested for committing another violent offense.
El caso por el que yo tengo fianza, ese caso se me cayó.
Yeah,
Ese
that
caso no
case
está
I
vigente.
is the case I was out on bond. That case was no pros. That case is gone.
I don't know if it is or not, ma'am.
Your Honor, that is incorrect. She does have a battery in Osceola, the 20 mm 2844. It is still open. She was referred to pretrial diversion for that.
Ese caso yo lo terminé.
And then there's also that open 21 CF 12024 that she just picked up September 4th.
All right, so ma'am, those cases are not dropped. You still have two open cases, one for a misdemeanor battery and one for a felony, both violent offenses. Again, you were then arrested for another violent offense. So today, I am not giving you bond. Call that number on that green piece of paper and ask to speak with the attorney assigned to your case as soon as possible.
All right, thank you.
Good luck.
But
Please tell me your name.
Efraín Rodríguez. Efraín Rodríguez. Efraín Rodríguez.
Efraín Rodríguez.
21 CF 12627, you're here charged with carrying a concealed firearm and petty theft. I'm going to appoint an attorney to represent you. There is probable cause in this case. Your bond is $1,000 on count one, $100 on count two. You can't possess a weapon of any kind, firearm or ammunition. You can't return to Walmart at 201 South Chickasaw Trail for any reason, and you can't have contact with any witness in this case. Good luck, sir.
Okay.
Okay.
Is that all we have for interpreter cases? All right. Thank you for your services this morning.
You're welcome, Your Honor.
Okay, so are we starting with second session?
We have some move-ups as well, Your Honor.
Oh, these are just move-ups?
Yes.
Okay. I gotta find him. Please tell me your name. All right, sir, you're here in 21 CF 12548, charged with burglary of a conveyance. A warrant was issued for your arrest. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you. I'll stay the bond at $2,500. I'm sorry? You don't want me to appoint an attorney to represent you? Raise your right hand, sir.
You try to tell the truth, whole truth, and nothing but the truth, help you God.
All right, sir, you just told me that you want to represent yourself in this case? Do you have any training or education in the law? Just get close to the microphone. I want to make sure I hear you. All right, and you understand that the state of Florida is represented by attorneys who went to law school, passed the Florida bar, and have been practicing in a court of law, right? So you'll be at a disadvantage if you're representing yourself. Potentially. And you still want to represent yourself. What's the highest level of education you completed, sir?
Excuse me?
What's the highest level of education you completed? Did you go to high school, college?
11th grade.
Did you say 11th grade?
11th grade, yes.
All right.
Your Honor, state would just point your attention to the second page of the information sheet, the last line, when making your determination.
Yeah, I see that.
Ask a question.
Yes, sir, you can ask anything you want. I just want to make sure you understand everything you say is being recorded and can be used against you later. Do you understand that? All right, go ahead.
What the charge is?
You got to get closer to the microphone.
What is the charge?
Oh, the charge is burglary of a conveyance.
Burglary of a what?
It's burglary of a vehicle, of a car, a motorcycle, a motorhome.
When did this occur?
I'm sorry?
When did this occur?
The allegation is that on or about September 10th, 2021,
I was locked up on September 13th.
on September the 10th.
September 13th.
All right, well, this was 3 days before that. That's the allegation.
Why ain't get charged then?
I can't answer that for you. This warrant was issued, oh, the warrant wasn't issued then. It wasn't issued until the 18th of September. So that's why it wasn't served on you, because it didn't exist at that time. Sir, do you have any substance abuse problems? Drugs or alcohol?
Of course I do.
All right, are you under the influence of anything today? So there's nothing that's impairing your ability to decide, to make decisions here today? Are you saying no?
No, ma'am.
Do you have any mental health issues?
Do I have any what? Of
Mental health issues?
course I do.
I can't hear you.
Of course I do.
You do? Okay, are you suffering from the effects of any of those issues this morning?
Always suffering from it.
All right, then here's what I'd like to do, Mr. Battle. I understand you told me that you want to represent yourself. You
Right.
do have a right to do that. But based on some of the responses that you just gave me, I'd like to appoint the public defender to represent you.
I don't need no public defender, because you charged me with a charge. I wasn't even there. I should have been charged then. Why you wait 8 days to charge me for a charge that happened on 10?
Sir, I'm not charging you with anything. I'm the judge. I don't bring the charges. That's the state of Florida.
Yeah, but I want to represent myself. I had that right. You can't.
You do have that right. But the court is concerned about some of your responses. Let me finish what I'm telling you.
Responses are dealing with.
Mr. Battle, let me finish what I'm telling you.
Let me tell you. Let me explain something to you.
Okay.
I got a mental health issue, but
Okay.
it's not to the point where I can't defend myself in court. It had nothing to do with it. My mental health issue, I'm diagnosed with antisocial personality disorder. That has nothing to do with what's going on right now.
Okay.
Other than that, I'm perfectly aware of what's going on. I'm just not understanding why we charge 8 days after. I don't understand it. You serve me a warrant 8 days after.
Sir, I don't serve
10
warrants.
days. I mean, what,
I'm not charging you. That's the state of Florida.
I'm ready to represent myself. I'm ready to get it over with now.
Oh, you can't. You can't plead to this today. So no matter what, you're not resolving this
What's
today.
the need to represent myself for if I can't get it over with? What we here talking about?
So
I don't understand it.
this is not going to be resolved today, no matter if you have an attorney or if you represent yourself. I cannot accept a plea to this charge today. And I can ask the state, does the state intend to file an announcement of no information today?
No, Your Honor.
All right, the state's not dropping it. You cannot plead guilty or no contest this morning. So the only thing that can happen is you or an attorney can enter a plea of not guilty, and we can set this for a trial date at a later time in front of the trial judge. But no matter what, you cannot resolve it today. Do you understand?
So my next court date is on. When will the next court date be held? In this courtroom or down?
It will not. It'll be downtown in front of a different judge, and I can't tell you what that court date will be.
I don't look. I would like to have my same judge with this right here. Is that all right too?
Which same judge?
David Johnson.
No, this won't be in front of Judge Johnson because this is a felony and Judge Johnson is a county judge.
Yeah, but see, it's regarding violating probation.
It's not.
I'm on probation.
Right, but this isn't about your violation of probation. This is about a new charge.
On probation right now, period.
I believe you, but this is a burglary charge, which is it's a felony, so it's going to be in front of a circuit judge. So here's what I'd like to do, Mr. Battle. I'd like to provisionally appoint the public defender's office to represent you so that you're not sitting in jail without an advocate. Now, later, if you want to fire the public defender's office, you can do that. But I'm concerned about leaving you sitting in jail without an attorney representing you at this time. Do you understand? All right, so I'm just going to appoint them provisionally. Like I said, if later down the road you want to fire the public defender's office, you have the right to do that and you can continue to represent yourself, okay? So your bond is $2,500. You can have no contact with the victim. You can't return to the scene.
So can I ask another question?
Yes, sir.
So what is attempted burglary? What's that? A felony too?
What is what?
What is attempted burglary?
So attempted burglary would be if you tried to break into a car or a house and you were unsuccessful. A burglary is if you actually did it.
So both of them are felony.
I'm sorry?
So is both of them a felony?
Yes, sir. They are. So that's why you can't resolve it today. But I'll ask Mr. Brantz, who's representing the public defender's office today, can you make a note for your colleagues and get someone down here to see him right away?
Yes.
All right, we'll try to get someone down here to see you right away, sir. Good luck. Please tell me your name.
Angel Torres.
#21 CF 12597. You're here charged with armed burglary of a structure with a firearm, armed trespass in a structure, criminal mischief, damage greater than $1,000, open carrying of a weapon or firearm, possession of cannabis less than 20 grams, possession of alprazolam, and carrying a concealed weapon. I'm going to appoint an attorney to represent you. There is probable cause in this case. Yes, ma'am, Ms. May?
Your Honor, given that count one, the armed burglary of a structure with a firearm is a life offense, state is that's going to make you hold him no bond pending an Arthur hearing.
Anything from the defense?
No argument, Your Honor, pending that hearing with his attorney.
All right. That is correct, sir. At this time, you'll have no bond on count one. Your bond on count two will be $5,000. Count three will be $150, four will be $100, five is $100, six is $150, seven is $100. You cannot return to Orlando Health for any reason. Well, I'll say without an appointment. If you have a doctor's appointment or it's an emergency, that's the only time you can return to any Orlando Health facility. Do you understand?
Yes.
You can't possess a weapon, firearm, or ammunition. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. All right, good luck, sir.
Thank you.
Please tell me your name.
Andrew Chico.
In 21 CF 12217, a warrant was issued for your arrest, charging you with burglary of a structure with assault or battery and petty theft with 2 prior convictions. Another judge has already found probable cause. I'll appoint an attorney to represent you. I need to look at this. Give me a moment. Yes, Ms. May?
Your Honor, given that the count one, burglary of a structure with assault or battery is a life offense, state is asking that you hold him no bond pending an Arthur hearing.
That is correct. I was wondering why it says $5,000 bond.
I'm not sure, Your Honor.
All right, you'll have no bond on count one. Count two will be $150. However, even while in custody, you can't have contact with any victim or witness in this case. And on count two, you can't return to Wawa. Do you understand?
Why won't I have a bond?
Because the first count is a first-degree felony punishable by up to life in prison. So at this time, you have no bond on that offense.
I have burglary of unoccupied dwelling.
That's a different case. We haven't gotten there yet. You have 2 cases today.
Okay, what's the first one you said I had?
All right, so the first case was the burglary of a structure with an assault or battery and petty theft. That's the one we just talked about.
Where was this at?
State, can you put the factual basis on the record?
1 second, Your Honor. On or about July 20th, 2021, law enforcement responded to the Wawa and met with the complainant or victim, Lizette Duncan. She advised that a white male with blonde dreads entered the store and entered the real employee-only commercial loading area. He took a red plastic bin and filled it with 4 boxes of Red Bull. the value estimated at $315.84. She confronted him to drop the merchandise. He dropped the bin and squared up to the victim, raised his hands into a fighting stance, and produced fear in Lizette that he was about to hit her.
I can't hear her.
Yeah, I can't really hear you either, counselor.
I don't know what she's saying.
On or about July 20th, 2021, law enforcement responded to the Wawa and met with the complainant, Ms. Duncan. She advised that a white male with blonde dreads entered the store.
All right, stop, sir. Are you unable to hear her?
I want to hear her again. No, she started talking to me, so.
Okay. Stand where they asked you to stand. Miss May, just get to the very important details that are the probable cause and maybe get really close to your microphone.
On or about July 20th, 2021, law enforcement responded to a Wawa. They met with the victim, who said that a white male with blonde dreads entered the store and entered the rear employee-only commercial loading area and picked up a large plastic bin filled with 4 boxes of Red Bull. She confronted him to drop it. He dropped it and squared up to Lizette, raising his hands into a fighting stance, and produced fear in the victim that she was about to be hit. He then reportedly fled south along John Young Parkway. All events occurred in Orange County, Florida.
And what is my charge for that?
That's burglary of a structure with assault or battery.
But then where's the assault at?
That's the assault. So an assault is placing someone in imminent apprehension of a battery. So if you act like you're going to hit someone, that's an assault.
I don't understand that.
It's okay. What we'll do is I'm appointing an attorney to represent you, and they can help you understand it. All right, so then your other case is 21 CF 12621. In this case, you're charged with burglary of an unoccupied dwelling, possession of cocaine, cannabis, paraphernalia, and lewd and lascivious behavior. There is probable cause for these charges as well. Again, I'll appoint an attorney to represent you. Your bond will be $5,000 on count 1, $150 on count 2, and $100 on 3, 4, and 5. You cannot return to this scene for any reason. You cannot possess or consume any controlled substance without a valid prescription. You can't have contact with any known drug dealers. You cannot have contact with a co-defendant in this case. All right, good luck, sir. Oh, I'm revoking your out on bond case.
You're welcome on the bond?
Yes. Please tell me your name.
Dominique Garrett.
21 CF 12575. You're here charged with possession of cocaine with intent to sell or deliver. I saw you yesterday. All right, Miss May.
Your Honor, the state was not able to obtain another affidavit from the officer, so state just asked that you find PC for possession of cocaine. And for the clerk, that statute is 893.13 sub 6 sub A.
There is probable cause for possession of cocaine. At this time, your bond will be $1,000. You can't possess or consume any controlled substance or have contact with any known drug dealers. Do you understand?
Yes, ma'am.
And sir, if you are a registered sex offender or sexual predator, you have to maintain your sex offender reporting requirements. You're not?
No, not at all.
Okay.
I don't even know why that came up.
Yeah, I have a note that says you are, but if you're not, it doesn't matter, but I just have to advise you.
I don't got no charges like that at all.
Your Honor, state would also ask for no contact with a co-defendant.
Like that.
Oh, you can't have any contact with a co-defendant.
Yeah, don't do me like that.
Listen, I just am reading what I've been given. I want to make sure you understand if you did have that, but if you don't, that's fine. Good luck, sir. Please tell me your name. 21 CF 12636. You're here charged with criminal mischief, damage greater than $1,000, and 3 counts of battery domestic violence. I'm going to appoint an attorney to represent you in this case. Hold on one moment. I need to pull up this case. There is probable cause in this case. Do either of you wish to testify this morning? Yes. All right, I need you to raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name for the record and spell your last name.
Magdalena Contreras, Contreras. Su nombre.
Elena García,
Letra de su apellido.
Garcias.
Sir, this is not a joke.
I had a burp.
This is a court of law. If you have to burp again, don't do it in my microphone. Do you understand? All right, we'll take one of you at a time. Who'd like to go first?
I'll go first.
I can't hear you. You have to get really close to the microphone.
I'll go first.
All right, the state might have some questions for you. You look at me or over here. Go ahead.
Good morning, Ms. Contreras. Can you please state your relationship to Mr. Conejo?
I'm his sister.
Are you afraid of him?
Right now, yes.
Has anything like this ever happened before?
No.
Are you willing to call 911 if anything like this ever occurred in the future?
Yes.
Do you believe drugs or alcohol were involved in this incident?
We assume, but we're not 100% sure.
Okay, and do you want to have contact with him while this case is pending?
I'm sorry?
Do you want to have contact with him while this case is pending?
No.
Great, thank you.
Any questions from the defense?
No questions, Your Honor.
Thank you.
Ms. Garcia, if you'll step towards the microphone, thank you. Can you please state your relationship to Mr. Conejo?
Es mi hijo.
She's the mom.
Does she need a Spanish
Do you need an interpreter?
Yes.
Is it Spanish?
Yes.
Just a moment. I don't know what just happened. I was looking at this, not that.
Good morning again, Your Honor. This is Theodore Leal, Spanish interpreter, previously sworn.
Good morning, thank you. Yes, I think I have a witness who needs your assistance. Could you please ask her if she needs the assistance of an interpreter?
Pregunto si usted necesita la ayuda de un intérprete.
Sí.
Yes.
All right, go ahead, Madam Prosecutor.
Good morning, ma'am. Can you please state your name for the record again?
Buenos días. Si usted, por favor, da su nombre para que consten las actas una vez más.
Sí, Elena García.
Perdón, el primer nombre.
Elena.
Elena García.
Thank you. And what is your relationship to Mr. Conejo?
¿Y cuál es la relación o parentesco que tiene usted con el señor Canejo?
Es mi hijo.
He's my son.
Are you afraid of him?
¿Y usted le tiene temor a él?
Sí, porque él ya me ha amenazado muchas veces.
Yes, because he has threatened me many a times.
Okay. So has anything like this ever happened before?
¿Y algo así similar ha sucedido en el pasado?
Sí, o sea, sí, siempre está peleando y agresivamente, así se pone.
Yes, it's always been fighting. He's always been aggressive. He gets like that.
Okay. And are you willing to call 911 if anything like this ever happened again?
Y si algo así como esto sucediese otra vez, ¿usted estaría dispuesto a llamar al 911?
Sí.
Yes.
Do you believe drugs or alcohol were involved in this incident?
¿Usted cree que estuvo de por medio en este incidente consumo de drogas o consumo de alcohol?
Bueno, él fuma marihuana y tomó cerveza.
Well, he smokes marijuana and he drank beer.
Okay. And do you want to have contact with him while this case is pending?
Y mientras este caso está en curso, ¿usted desea mantenerse en contacto con él?
No, porque me va a ofender.
No, because he's going to be offensive towards me.
Understood. Thank you, ma'am. That's all I have, Your Honor.
Entendido, señora. Gracias. Y eso es todo para la juez.
Anything from the defense?
No questions, Your Honor.
¿Algo de la defensa?
Voy a llevar a un psicólogo.
Ma'am, I have a question.
Señora, yo tengo una pregunta para usted.
Sí,
Yes.
Was your son living with you?
¿Su hijo vivía con usted?
sí.
Yes.
All right. Is there anything else you want to tell the court today?
¿Y hay algo más que usted desea informarle al tribunal el día de hoy?
Sí.
Yes.
Go ahead.
Lo que pasa es que él ya tiene como un año y algo que fue a vivir conmigo y él habla solo y pelea solo en el cuarto y no quiere ir a la calle. No sé qué le pasa, está como loco y eso me pone a mí. A mí me operaron, me maldició, me dijo que me muriera y muchas cosas me dice cuando está enojado y me da miedo que me haga algo porque yo pienso que él está psicológicamente mal.
Yes. The thing is that, he moved in with me. It's been a year since he started living with me, and sometimes he argues by himself in the room. He doesn't want to go outside onto the street. I really don't know what's going on with him, and I was operated recently, and he was cursing at me, wishing me that I die. Whenever he gets upset, he gets like that, and I am quite afraid because of something he could do to me, and I think he's got psychological problems.
All right. Thank you, ma'am. I appreciate you both coming this morning.
Gracias, señora. Les agradezco que ambas hayan venido hasta aquí en esta mañana.
At this time, his bond is $1,000 on count 1,
En este momento se le va a dar una fianza a él de $1,000
$500 on each count 2, 3, and 4.
y que ese es para la primera el cargo, pero los cargos 2, 3 y 4 van a ser $500 cada uno.
He can have no contact with either victim or any witness in this case.
Y a él se le va a prohibir el contacto tanto con las víctimas como testigos de este caso.
He cannot possess a weapon of any kind, firearm or ammunition.
A él se le prohíbe también el porte y uso de armas o de armas de fuego o de municiones.
He cannot possess or consume any alcoholic beverages or controlled substances without a valid prescription, and he'll be subject to random screens.
Él también se le prohíbe el consumo de alcohol, el consumo de drogas, a menos que tenga algún medicamento prescrito por un médico, y se le van a hacer exámenes antidrogas al azar.
He'll have to maintain a separate residence, and I'll allow one-time return with law enforcement to gather his belongings.
Y él va a tener que estar viviendo en otra residencia. Podrá volver una sola vez a recoger sus efectos personales en compañía y vigilancia de la policía.
I'm ordering that he's not allowed to live with you, but he can go with law enforcement officers one time to gather his personal belongings, and then after that, he can't go back to your house.
Entonces, él ya se le prohíbe vivir con usted, se le está permitiendo ir una sola vez para que recoja sus efectos personales, vigilado por un policía, pero después de eso ya no puede volver más, se le prohíbe.
Una pregunta más, pero yo tengo miedo que él vaya y destruya golpee las ventanas y me destruya la casa, porque él en su enojo él fue lo que me dijo que iba a desbaratar la casa, y tengo miedo que me haga a mí algo cuando llegue y eso.
Well, the thing is that I'm so afraid that he goes there and he's going to destroy the windows and destroy the house. That's what he said that he was going to do when he got upset, that he was going to wreck the house. And that's what I fear for.
He will only be allowed to be at your house one time with law enforcement. So police officers will be with him. He will not be able to destroy anything in the presence of police.
Sí, no, es que se le va a permitir que vaya una sola vez, pero él va a ir acompañado por la policía. Y él no va a poder hacer nada en presencia de la policía, no va a poder destruir nada porque la policía va a estar ahí.
If he comes to your house without a police escort, that's a violation of this court's order. You can call the police if you wish. He could be he'll be arrested for violating my order.
Sí, y si él se aparece en la casa y no está presente o en compañía o escoltado por un policía, entonces él estaría automáticamente violando esta orden emitida por el tribunal. Y en ese momento usted puede llamar a la policía y él sería arrestado por violar esta orden de la corte.
Good luck. Thank you for coming.
Buena suerte y gracias por venir.
Your Honor, we'll wait.
Your Honor, if the interpreter could just have the case number before disconnecting, the name and the case number, sorry.
Does someone else have it?
2021 CF 12636.
And it's Cornejo, you said? Sorry.
Yes.
Thank you very much.
Hold on. I believe that's all we need from the interpreter. Thank you.
Welcome, Your Honor.
What, Mr. Brands?
We'll waive his appearance.
All right, thank you. Sir, please tell me your name.
My name is Cardell Henry Evans III.
21 CF 12593. You're here charged with aggravated battery, domestic violence. I'm going to appoint an attorney to represent you in this case. There is probable cause here. Your bond is $5,000. You can have no contact with the victim. Do you understand what no contact means?
You said $5,000?
Yes.
I understand.
All right, you can't possess a weapon, firearm, or ammunition. I'll order you must maintain a separate residence and allow a one-time return with law enforcement to gather your belongings. Good luck, sir. That's it. Please tell me your name.
Amari Lloyd.
21 CF 8010. A warrant was issued for your arrest, charging you with aggravated assault with a firearm. And the state filed an information. Let me see what they charged.
We did, Your Honor. We filed an ag assault with a deadly weapon, an F3.
All right. So another judge found probable cause and the state's already filed the charges against you. Let me ask, ma'am, did you wish to testify here today?
Yes.
Please raise your right hand to be sworn.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please state your name for the record and spell your last name.
Santrell Regina Lloyd, Lloyd.
All right, I'm going to ask if the prosecutor has some questions.
Good morning, Miss Lloyd. Can you please state your relationship to Mr. Lloyd?
I am his mother.
Are you afraid of him?
No, ma'am.
Has anything like this ever happened before?
No, ma'am.
Are you willing to call 911 if anything like this ever occurred in the future or anything more severe?
Yes, ma'am.
Do you believe drugs or alcohol were involved in this incident?
No, ma'am.
And do you want to have contact with him while this case is pending?
I do.
All right, thank you. That's all I have, Your Honor.
Anything from the defense?
No questions, Your Honor.
All right, ma'am, is there anything else you'd like to tell me?
Yes, ma'am.
Go ahead.
I would just like to say, before he was actually, a warrant was issued, I spoke to the detective and I let them know that I was under extreme grief. I had just lost my sister, my niece, and my grandmother. So the event in question was cloudy after I, calmed down. So I let him know that I didn't want to move forward. He let me know that everything would be, fine. He would get in contact with the advocate and the state attorney before they filed. But apparently somehow it still got filed. So that's why we're here today.
All right, thank you. Does he have a hold for like a warrant out of Miami-Dade? What's the warrant for?
It's for his, I guess, juvenile probation for robbery.
He was on probation for a robbery?
I guess he's on Jack, so yeah. For a juvenile custody order.
Right. But is it for violating probation on a robbery, or is it for, sorry, I'm trying to understand what this is.
I believe it's juvenile probation, Your Honor.
What?
I believe it's juvenile probation. For that
But the charge was robbery and he was placed on probation for a robbery, or he violated that with a robbery?
He wasn't on probation.
Miami-Dade thinks he was.
From my knowledge, he wasn't, and it was a cell phone that he took from somebody, so it really wasn't, I don't know, y'all probably still call that a robbery, but the person got it back, so it's supposed to be dropped, but he missed court, so that's a whole nother issue too.
Okay. I have that he has a hold out of Miami-Dade. So are they going to transport him to Miami?
Yeah, it's a hold for him. I'm not too sure it's probation or not. It's just a hold for Jack out of Miami-Dade, and it's a no bond.
All right, thank you.
Your Honor, there's also other history that isn't reflected.
Are there any convictions? I see a grand theft of a motor vehicle.
It is a 2020 grand theft motor vehicle where it was withheld, a 2019 grand theft that was withheld, a 2019 grand theft motor vehicle that was withheld, a 2018 battery that was withheld, and then a 2017 battery that was withheld, and then some other charges that were ultimately dropped.
All right, thank you. All right, Mr. Lloyd, at this time, your bond on this charge is going to be $5,000. I'm going to order that you can have no contact with the victim. You can't possess a weapon of any kind, firearm, or ammunition. I'm going to order you have to maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings.
Okay.
I don't think you're going to be released even if you post bond because Miami-Dade is going to transport you down there. They have a warrant for your arrest with no bond. Did I appoint an attorney? Okay. All right, good luck, sir. Thank you, ma'am, for coming. Good luck. Please tell me your name.
Even after the middle.
21 CF 12624. You're here charged with aggravated battery domestic violence. There is probable cause, and I'll appoint an attorney to represent you in this case.
Your Honor, given his history, state would ask for a bond that reflects that, and given the injury sustained by the victim. He has multiple other violent convictions, multiple batteries, ag assault DVs, stalking.
Oh, yeah. All right, sir, your bond on this is $5,000. You can have no contact with the victim. Do you understand what no contact means?
Yes, thank you, ma'am.
You can't possess a weapon of any kind, firearm, or ammunition. You have to maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings. Any other conditions the state would request?
No, ma'am.
No, Your Honor.
All right, good luck, sir. Please tell me your name.
Anna Sandoval.
21 CF 12634. You're here charged with domestic battery by strangulation. At this time, I'm going to appoint an attorney to represent you. There is probable cause. Does the state object to pretrial release?
Yes, Your Honor, and if you're otherwise inclined to put her on it, state would ask for bond with PTR. Given the continued nature of this offense, I believe she followed her all around the house and ended up allegedly strangling her at least 3 times. So due to the elongated nature of the offense, state would object at this time. We also don't have the victim's input here today.
Mr. Brantz, any response?
Just a reasonable bond in your discretion, Your Honor.
At this time, your bond is $2,500. You can have no contact with the victim. Do you understand what no contact means?
How long is that for? Or I don't know, I've never been in trouble with the law, so I don't.
All right, so you understand what no contact means. You can't call her, you can't speak to her, you can't text her, you can't send a message through friends and family, you can't contact her on social media, no contact at all. That lasts until another judge changes my order. You can't possess a weapon of any kind, firearm or ammunition. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings, but you cannot coordinate that with the victim. Do you understand?
Yes.
Any other conditions the state would request?
Your Honor, there's an allegation of alcohol.
You're not allowed to possess or consume alcoholic beverages, and you'll be subject to random alcohol screens. Good luck, ma'am.
I'll get screenings for alcohol, you said?
Yes. So you cannot drink.
Okay. Thank you.
Yes, ma'am. Please tell me your name.
Lieutenant Earl Towns III, ma'am.
21 CF 12592. You're here charged with aggravated assault, dating violence, and battery dating violence. There is probable cause. I'll appoint an attorney to represent you in this case. He has an active warrant for a hit-and-run charge out of Georgia.
Your Honor, he also has an open 2021 misdemeanor non-arrest case, a
What is
BAT
that?
TV against
That-
the
It's the same victim?
There's also a 2021 felony ag assault TV. That's all I have within Orange County, Your Honor, to bring to your attention, that 2021 misdemeanor non-arrest.
All right, thank you. How old was the child, the son? Do you have that information?
I don't believe so, Your Honor.
I don't see it.
I'm not sure, Your Honor.
All right, on count one, your bond is $15,000. On count two, it's $100,000. You can have no contact with either victim in this case or any witness. Do you understand what no contact means? You cannot possess a weapon, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings. Mr. Brandt, I'm considering ordering your client that he can't drive.
He does have a valid license, Your Honor.
He may have a valid license, but he has a warrant for a failure to appear in a hit and run out of Georgia. The allegation in this case is that he was trying to hit and run his, whatever her relationship is with him.
Girlfriend, I believe, Your Honor.
He has prior hit and runs in Florida.
As well as aggravating, fleeing, and attempting to elude. He has a prior Willis.
Yeah. You can't drive. Until a judge allows you to drive, you can't drive. Do you understand?
Yes, ma'am. I have no license. I don't have I don't even have a hit and run in Florida, ma'am. I don't.
All right, well-
I'm not understanding where that's coming from. But I do have the warrant in Georgia. I've had it since 2006 for hitting a tree and pulling off after that. That's what I did. But I do have that in Georgia, and that's understood. It's a no pickup without a 100-mile radius of the county. I've been trying to get cleared up since I've been home, but I haven't been able to. That's why I don't have a license. But yes, ma'am.
How do you get to work?
I get a ride. But she used to take me to work, or I would catch an Uber.
You have a job?
Yes, ma'am.
All right, strike that last one, that he can't drive. I'm not going to order that. All right, good luck, sir. Get in touch with your attorney.
Yes, ma'am.
Bernard Wright is medical.
21 CF 12583, Mr. Brandt, I'm going to appoint your office.
We'll waive the appearance, Your Honor.
All right, there is probable cause in this case. Hold on one moment. Bond is $5,000 on count one, 100 on count two, no victim contact, no weapons, firearms, or ammunition, maintain a separate residence, one-time return with law enforcement. That's it on that one. Please tell me your name.
Lloyd Anthony Cummings Jr.
21MM618, you're here charged with battery, dating, violence. I'm going to appoint an attorney to represent you. There is probable cause in this case. Your bond is $500. You can have no contact with the victim. Do you understand what no contact means?
Don't call them or speak to them or text them.
Right, no contact at all. You can't possess a weapon, firearm, or ammunition. Were you two living together? No? Okay, so I'll order that you can't return to her residence for any reason.
But my stuff is there. So I was living, but it's not like a long time. Like it was like 3 weeks, like the beginning of September.
Okay.
Your Honor, their addresses are the same.
Okay, I'll order that you must maintain a separate residence and allow a one-time return with law enforcement.
Okay.
What, Ms. May?
I was telling you the victim lists the same address as Mr. Cummings.
Okay, all right.
No.
So you understand? You can go back and get your things with law enforcement.
Yes.
Okay, good luck. Please tell me your name.
Timothy Michael Ramsey.
21MM6676, you're here charged with battery domestic violence. I'm going to appoint an attorney to represent you. There is probable cause in this case. Your bond is $500. You can have no contact with the victim. Do you understand what no contact means?
Not talk to them.
You can't speak with them, you can't text, you can't send a message through friends and family, you can't contact them on social media. This is no contact at all.
Okay.
You can't possess a weapon of any kind, firearm, or ammunition. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings. And at this time, I'm revoking your out on bond case 21 CF 8870. Wait, does he have two?
It's just one.
I just see one, Your Honor.
Oh, okay, I got it. All right, good luck, sir.
Ms. Davis, do you know if he was on PTR for that case?
Yeah.
He was.
Thank you.
Please tell me your name.
Howard Williams.
21MM6670, you're here charged with battery domestic violence. There is probable cause. I'll appoint an attorney to represent you. Does the state object to pretrial release in this case?
Your Honor, given the allegations and given that there was an independent witness saying that he saw her holding her head down and punching her in the head and face, state would object, but would ask that you set bond with PTR.
Mr. Brandt, anything from the defense?
Nothing from the defense, Your Honor.
All right.
I believe it was the victim's own testimony also to the law enforcement officer, that she'd been trying to get him out for months.
All right, I'm going to place you on pretrial release and require that you post a monetary bond of $250. With special conditions, you can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon of any kind, firearm, or ammunition. You must maintain a separate residence. I will allow a one-time return with law enforcement to gather your belongings, but you cannot coordinate that with the victim. Do you understand?
Yes, ma'am.
Any other conditions the state would request?
No, Your Honor.
All right, good luck. Please tell me your name.
Richard Gotrio.
All right, just a moment. It looks like you have a warrant out of Seminole County for violating probation on a charge of lewd and lascivious assault. There is no bond. I'll appoint an attorney to represent you. We'll notify them that you're here so that they can transport you. Because I don't know the dates of all of these things, I'm going to take no action on the out on bond. Good luck. Sir, please tell me your name. Sir? All right, Mr. Smith, you have a warrant out of Seminole County, looks like 221 CF 2298 for tampering with an electronic monitoring device. There's no bond authorized. Oh, it says, on one place it says no bond, on another, no bond until first appearance. Sir, you can ask anything you want. I just want to make sure you understand that everything you say is being recorded and can be used against you later. Do you understand?
Tampering with an electronic device, what does it entail?
Wait, get closer to the microphone because I can't hear you.
It's been storming rainy for the last few days. Now I'm homeless, got caught in the rain. Maybe the water got into it when they're saying I'm tampering with it. I've never touched it one way or the other to take it off or anything other than that.
All right, I understand. I believe you, but you're going to have to raise that defense in Seminole County in front of that judge.
Yes, sir.
Because the judge issued a warrant for your arrest. I can't change that.
Right.
I'm going to set your bond at $5,000. So if you're able to post bond, you can be released. If not, they'll come and transport you, and I am appointing an attorney in the meantime.
Your Honor, they would ask that that remain no bond, given that the warrant is apparently vague. Due to his prior history and given that he apparently was on a ankle monitor, and now he allegedly is not on it due to the tampering.
What's his prior history?
He, about 2 months ago, pled to a trespass. He has an open orange lewd act upon a child. He has another open orange.
What?
What?
What's the open orange?
This is Mr. Smith, correct?
I'm a child.
This is Albert Smith.
You got the wrong name, you got the wrong.
Your Honor, according to CCIS, with Mr. Smith, with his date of birth, the 11/16/63, I have a 2020 possession of cocaine, paraphernalia. We didn't go forward on the robbery and battery. He has a petty theft 2 prior. He has a robbery. He has several prior failures to appear. He has a petty theft, cocaine and paraphernalia, resisting without, cocaine, paraphernalia, loitering, paraphernalia, resisting with, and possession of controlled substance, petty theft 2 prior, battery, resisting without. Controlled substance times 3, open container, petty theft, resisting without, paraphernalia, controlled substance, paraphernalia, petty theft prior. We didn't go forward on an agbat, great bodily harm, and a robbery and snatching, false ID to Leo, petty theft 2 prior, paraphernalia, battery by a detainee in a detention facility, for conveyance, petty theft, battery, petty theft 1 prior, paraphernalia, petty theft, robbery and snatching, no valid, and that is history from 2001 until to date from CCIS.
Your Honor, if the warrant allows you to set a bond, I find that bond that you've said reasonable. I would just continue with that bond amount.
Your Honor,
I wouldn't be able to get out anyway, man. Anyway.
I would
Your Honor, state's only concern is he was on an electric monitoring device. I don't know the underlying facts for that Seminole case. And given that allegedly he was tampering with it, potentially by his admission of potentially some rain, or potentially something else. I don't have the exact facts on that.
So, sir, again, you don't have to explain anything, and it can be used against you later. Do you understand that?
Of course, I understand that, but still, it doesn't matter one way or the other. I mean, it's gonna benefit me more than it hurt me, to be honest with you. I lost, somebody stole my charger. I called Seminole County. They responded. They said somebody will be sending you another charger from Seminole County. When they brought the charger to me, they waited, they knew where I was at. Yes. I went to this apartment complex where I normally go to charge it. And before you charge it, you have to boot it. You have to reboot it. So I have to push that phone thing, you know, and that's what they're talking about, tampering with it. Because the police was there to watch me and had to help me reboot it before he can leave, you know? And that's just a few days ago. And they just put the one out for me just 2 days ago, 2 days ago. But all these, that's what they're talking about, I mean, rebooting it. But the Seminole County officer rebooted it.
All right, well, I think, again, it sounds like you think you have some defenses. You're going to have to raise them in Seminole County. I appreciate the state at least giving me his criminal history because I didn't have access to that. But since the warrant, I think it's confusing because it says no bond and then it says no bond until IAs. I'm disinclined to hold him at no bond. However, based on his criminal history, I'll raise it to $15,000. So get in touch with your attorney right away, sir, okay? Good luck. Please tell me your name.
Brian Feliciano Rivera.
It looks like you have two VOPs, 20 CF 3921. Mr. Brands, your office already represents him.
We'll enter a denial on the violation of probation, Your Honor.
Oh, I think they're on views. There's no bond. And then the other one is 20 CF 4003. If that's also an on view, it'll have no bond, but you're representing him in both.
Yes, Your Honor.
All right, get in touch with your attorney right away, sir. Good luck.
Good. Medical.
20 CF 123. Mr. Brands, I'll appoint your office.
We'll waive the appearance, Your Honor.
All right, there's no bond at this time.
Neil Gordon?
Wait, who does?
No. That add-on bond case is what caused the violation, so it's not add-on bond.
Okay, thank you.
Gotcha.
What were you saying? Oh,
You just stated his name.
Neil Gordon?
19 CF 5503. You're here for a violation of probation. I'm going to appoint an attorney to represent you. At this time, there's no bond on this. The allegation is that you were arrested for committing the criminal offense of carrying a concealed firearm, possession of cocaine, possession of drug paraphernalia.
Yes, ma'am.
All right, so hold on, let me tell you. I'm just telling you what the warrant says today. We're not going to have a VOP hearing today. So if you think you have some defenses, you want to call your attorney right away, call the number on that piece of paper, get to speak with your attorney, because you have to raise those in front of the trial judge.
Okay.
I can't change their warrant.
Yes, ma'am.
All right, good luck, sir. Please tell me your name. One more time.
Just put your hands down, that's all. There you go.
I can't hear his name.
What you say?
What's your name?
DeAndre Johnson.
I don't have this anywhere. What's his charge?
You have the booking number?
I don't have him.
I don't either.
He bonded on everything. He just still has a hold for VFOSC because of the new charges, but we don't need to see him.
Oh, sorry, sir. Good luck.
The possession of meth and the possession of cannabis.
Possession of what?
Meth and possession of cannabis.
Christina Lemare.
20 CF 9158, you're here for a violation of probation. I'm going to appoint an attorney to represent you in this case. The allegation of violation is you failed to report as directed several times. And there's no bond at this time. Good luck, ma'am.
Morning.
What's your name?
Lazo Pender.
19 CF 3188. Sir, you're here for a violation of probation. I'm going to appoint an attorney to represent you. There's no bond on this warrant. The allegation is that you are arrested for committing the criminal offense of battery dating violence. All right, good luck, sir.
Your Honor, I believe some of the paperwork has 19 CF 3138. I just want it to be clear that the case number is 19 CF 3188.
That's what I have in Odyssey.
38?
3188.
3188. 88 is correct, Your Honor. Some of the paperwork says 38.
Okay.
William Frank Sesser?
21 MM 3943.
Yes.
You're here for a violation of probation. The allegation is you did not comply with instructions given to you by probation. At this time, there's no bond authorized, and I'll appoint an attorney to represent you. Good luck, sir.
I can't. I've been in the hospital, Advent Health in Orlando, had a stroke and heart attack.
Oh, I'm sorry.
And for about 6 weeks, I was in Spring Lake, New Jersey, and Point Pleasant in hospitals there. So
I think it sounds like you're saying you have some defenses to the
I'm 7
violation.
years old. I'm not sure what you're talking about.
Well, so the allegation is that you were placed on probation by a judge, and then you didn't report to probation as instructed. They gave you instructions, and you didn't do what you were supposed to do.
That's not true.
So, sir, you're going to have to call your attorney because we cannot have a contested hearing here today.
Attorney's on tape, Lou Esposito from Cedar Grove here.
Okay, so you don't need the public defender?
No,
All right, I'm not going to appoint them in this case then? You have your own attorney?
yes,
Okay, so you need to call your attorney right away.
yes, he sent a tape here.
Okay, well, it won't come to me. It needs to go to the judge who placed you on probation.
Okay, well, I was in the hospital on those dates. with
Right.
Blue Cross Blue Shield in Florida and in New Jersey.
So what's going to happen is you need to call your attorney and make sure that they understand that. Okay, because they're going to be able to present that to the judge who placed you on probation. We can't have a hearing today.
Yes, I was in the hospital.
I understand. So call your attorney.
Yes.
Your Honor, I believe the PD, or the PD's office was representing him.
Oh, all right, I'm going to reappoint the PD.
Keep it on there.
Mr. Brantz, that's a misdemeanor. Do you want to enter a denial?
We can enter a denial, Your Honor, get a court date.
Yeah, go ahead.
Thank you.
BOP status day will be October 25th at 8:30 a.m., Courtroom 4B.
Please tell me your name.
Carissa Alberti.
21 CF 7151. Looks like a capias was issued for your arrest in this case for failing to appear on a charge of petty theft with 2 prior convictions. There's no bond authorized, and I'll appoint an attorney to represent you. Good luck.
David Ambrosio.
21 CF 2647. A capias was issued for your arrest for failing to appear on charges of possession of cocaine and paraphernalia.
Yes, ma'am.
There's no bond authorized, and I'll appoint an attorney to represent you in this case. Good luck, sir.
Daniel Bates.
Thank you. 21 CF 12626. You're here charged with possession of methamphetamine. There is probable cause. I'll appoint an attorney to represent you. Your bond is $1,000. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Do you understand? Is that a yes?
Yes,
All right, good
ma'am.
luck, sir. Please tell me your name.
Shalonda Brand.
21 CF 2986. You're here because a capias was issued for your arrest for failing to appear on a charge of possession of a controlled substance. The bond authorized is $2,500. I'll appoint an attorney to represent you. Good luck.
I'm sorry, my bad. Damian Brown.
Mr. Brown, you're here in 21 CF 12629, charged with attempted first-degree murder of a law enforcement officer with a firearm and aggravated assault with a firearm. At this time, I'm going to appoint an attorney to represent you. Ms. May, did the state wish to be heard?
Yes, Your Honor. Given count one, the attempted first-degree murder of a law enforcement officer with a firearm, as it is a life offense, state is asking that you hold him no bond pending an Arthur hearing.
Mr. Brands?
No argument, Your Honor, pending that hearing with his attorney.
All right, I will do that, sir. At this time, you'll have no bond on count one. Your bond on count two will be $25,000. Even while in custody, you can have no contact with any victim, witness, or co-defendant in this case. Do you understand what no contact means?
Yes, ma'am.
Once released, so only on count two, I guess, at this time, you can't possess a weapon of any kind, firearm, or ammunition. Again, no contact with any co-defendant. Are there any other conditions the state would request?
No, Your Honor, given that he's held no bond.
And I'm
Right.
sorry, what was the bond on count two, Your Honor?
25,000?
Okay, thank you.
All right, good luck. And you guys have no contact in here, right?
Yes.
Okay.
Alice Carmack.
21 CF 12630, you're here charged with grand theft. There is probable cause. I'll appoint an attorney to represent you. One moment. Your bond is $1,000. You can't return to the scene. You can't have contact with any witness or the co-defendant in this case. Do you understand?
Yes.
Good luck.
How you doing? My name is Jonathan Carter Jr.
Thank you. 21 CF 12628. You're here charged with battery on a law enforcement officer and resisting an officer with violence. There's probable cause. I'll appoint an attorney to represent you in this case.
Yes, ma'am.
Your bond is $5,000 on count one. $150 on count two. You can't possess a weapon, firearm, or ammunition. You can't possess or consume any controlled substance without a valid prescription. You can't have contact with any victim or witness in this case. Do you understand?
Yes, ma'am.
All right, good luck, sir.
All right.
Please tell me your name.
Christopher Cutler.
21 CF 12457. You're here charged with lewd or lascivious molestation. I'm going to appoint an attorney to represent you in this case. Hold on one moment. A warrant was issued for your arrest, so another judge has already found probable cause. Ms. May, did the state wish to be heard?
Yes, Your Honor. Given that he's charged with a life offense, state is asking that you hold him no bond pending an Arthur hearing.
Mr. Brands?
No argument, Your Honor, pending that hearing with his attorney.
Oh, thank you. On him? Oh, hold on one moment. Okay, let me do this one. So at this time, you'll have no bond on this charge. However, even while in custody, you can have no contact with the victim or the victim's immediate family members. I understand those are your immediate family members. You cannot have contact with them. Do you understand?
Yes, ma'am.
All right. At this time, let me review this affidavit for a violation of probation. It says that while you are on probation for reckless driving, you violated by committing the offense of lewd or lascivious molestation. I reviewed that affidavit and warrant. There is probable cause there. At this time, I'm going to sign this warrant. And you'll have no bond on this as well.
Your Honor, is that a VOP for 21 CT 2082?
It is.
Thank you.
I'm going to appoint the public defender's office in that as well. Thank you. Good luck, sir. Good job.
Richard Michael Dean.
21 CF 12541. Thank you. You're here charged with lewd or lascivious molestation and lewd or lascivious exhibition. I'm going to appoint an attorney to represent you in this case. It's a warrant, so another judge has already found probable cause here.
Just a moment to confer, Your Honor.
Yes.
Thank you, Your Honor.
Does the state wish to be heard on bond here?
Your Honor, I was trying to confirm, on the affidavit, it's charged 5D. On the warrant, it's just charged 5. Given the victim's ages, I believe it is 5D, as the victim was between the ages of 12 and 15. As the clerk site has it as an F1, I do not believe that's true, since it's just charged with 5. I do believe it's an F3 on count 1, so he is entitled to bond, and it's an F2 as to count 2. So given that he is entitled to bond on both of these charges, they would ask for a reasonable bond. However, would just ask for you that you take into account, while he has no criminal history, the charges before the court are serious, as well as he does have a new law offense as well. So while he has no history, it seems like he's quickly racking up history, of which so state would just ask that you set a reasonable bond, Your Honor, given the seriousness of the offenses and that they are sexual in nature.
Does the defense wish to be heard?
Your Honor, I do concur with the state that the, under the statute, it is a felony of 3rd degree, so he's entitled to a reasonable bond, as well as the very thin criminal history. He's also a Marine veteran, so I would have you consider that as well in your bond determination.
All right, at this time, sir, your bond will be $5,000 on count 1, $25,000 on count 2. You can have no contact with any victim or witness in this case. Do you understand what no contact means?
Yes, Your Honor.
You can't return to the Spring Hill Suites for any reason. You can't have any contact with any minor child under the age of 18. You can't possess or consume alcoholic beverages. Are there any other conditions the state would request?
No, Your Honor.
Good luck.
Thank you, Your Honor.
Sir. Please tell me your name.
Ricardo Delgado, man.
21 CF 12609, you're here charged with aggravated assault with a deadly weapon. There is probable cause. I'll appoint an attorney to represent you in this case. Hold on, I gotta pull up the sheet.
There was no weapon recovered, man.
So the charge is that you assaulted someone with a deadly weapon, not that they recovered it. So there is probable cause. Now, whether the state can sustain that to a jury verdict, I don't know. That's up to the state. At this time, all right, your bond is $15,000 on this charge. You can have no contact with any victim or witness. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon of any kind, firearm or ammunition. Do you live here where this happened?
No, man. I live in Orange Ave.
All right, I'll order that you're not allowed to return to this scene for any reason. You can't possess or consume any controlled substance or have contact with any known drug dealers. And at this time, I'm revoking your out on bond cases. Good luck, sir. Please tell me your name.
James Edward Douglas.
Thank you, sir. You're here in 19 CF 17330. It looks like a capias was issued for your arrest here for failing to appear for a hearing on charges of burglary of an occupied structure and grand theft. At this time, I'm going to appoint an attorney to represent you in this case, and you have no bond.
Ms. Gibson, I was arrested on December 19, 2019, and my defendant was, my public defender was Brittany Sarah Beers, and she wrote me the case. She said that my charge was only grand theft in 2020, and the reason that I was not appearing in court in February when the capias was issued was because I was in Duval County Jail with my mom. I went to visit my mom for Christmas because in 2020, I was locked up since May 14th, 2020 for trespassing for 6 months, and they didn't let me go to court. And I'm requesting that may the Lord's grace be with me and I'll be released on my own recognizance to return because I do live here in Orange County.
Well, I appreciate all of that, but I can't change another judge's capias. It's a function of the law. I'm not allowed to.
Oh, okay.
So call your attorney right away.
Okay.
Tell them that because they can say that to the judge who issued the capias and that judge can change it.
Okay, is my judge still Miss Barbara?
It should be.
Barbara,
Yes, Elaine Barber.
Yes, yes.
Yes, it should be her. Yes, sir.
Right now?
Yeah, call your attorney. Call your attorney.
Okay, thank you.
Yes, sir, good luck.
Is she gonna let me out today?
I doubt that it's gonna be today because they have to get a hearing in front of the judge.
Okay, thank you.
Yes, sir, good luck.
How long would that be if you don't know my law?
I don't know, but call your attorney today and tell them to get it started. Please tell me your name. Oh, sorry. 21 CF 4620. An indictment was filed charging you with first-degree murder with a firearm.
Your Honor, we have since filed an information charging second-degree murder with a firearm, which is still a life offense. So the state would ask that you hold a no bond pending an Arthur hearing.
All right, I'm going to appoint an attorney to represent you. Mr. Brandt, any response?
No argument, but he is entitled to that Arthur hearing with his attorney.
All right, at this time, you'll have no bond. However, even while in custody, you can have no contact with the victim's family or any co-defendants. Do you understand? Good luck, sir.
Skylar Jones.
21 CF 11488. A warrant was issued for your arrest, charging you with attempted burglary of an occupied dwelling, nope, that's a different charge. 11488 is aggravated battery on a pregnant person and aggravated assault with a firearm. That is also a warrant. I'm going to appoint an attorney to represent you in this case.
Your Honor, state would just bring your attention to he has a fairly significant history, a lot of which include other batteries.
All right, your bond on count 1 will be $5,000. Count 2 will be $5,000. You can have no contact with any victim or witness in this case. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon of any kind, firearm, or ammunition. You must maintain a separate residence from all victims. I'll allow one-time return with law enforcement to gather your belongings. In 21 CF 8565, another warrant was issued for your arrest, charging you with attempted burglary of an occupied dwelling and criminal mischief. I will appoint an attorney to represent you in that case as well. Your bond will be $15,000 on count 1 and $100 on count 2. You cannot return to this scene for any reason. Do you understand?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. You can have no contact with the victim in this case either. Any other conditions the state would request?
No, Your Honor.
Good luck, sir.
José Maldonado Martínez.
21 CF 12617, you're here charged with possession of cocaine, fentanyl, and drug paraphernalia. There is probable cause. I'll appoint an attorney to represent you.
Your Honor, as he has a limited criminal history and he does otherwise qualify, would you consider straight PTR on the charges?
What says the state?
Your Honor, state has no objection.
I'm going to place you on pretrial release. With special conditions, you cannot possess or consume any controlled substance. You'll be subject to random drug screens, and you can't have contact with any known drug dealers. Do you understand?
Yes, ma'am.
Good luck, sir.
David Abado.
I need his name one more time, sorry. No, not him. It's not something,
Oh, that's it?
no, I don't need him again. Sorry for the confusion.
David Albano.
21 CF 12631, you're here charged with burglary of a conveyance with assault or battery and criminal mischief. I'm going to appoint an attorney to represent you. Does the state wish to be heard?
Yes, Your Honor, given count 1 as it is a life offense, state is asking that you hold no bond pending an Arthur hearing.
First, let me say there is probable cause. Mr. Brantz, any response?
No argument from the defense, Your Honor, but he is entitled to that hearing with his attorney.
All right, at this time, you'll have no bond on count 1. Your bond on count 2 is $1,000. However, even while you're in custody, you can have no contact with any victim or witness in this case. Do you understand?
Yes.
On count 2, you also can't possess a weapon of any kind, firearm, or ammunition, and you can't return to the scene. Good luck.
Nagana, Eugene, he refused court.
21 CF 12623, I'll find his refusal a willing waiver of his appearance today. Mr. Brantz, I'm still going to appoint your office to represent him.
Your Honor, can I be heard on the
Count 4?
count 4, yes.
Yes.
As to probable cause for introducing contraband into a detention facility, as to the facts in the arrest affidavit, they were in the parking facility and the alleged substance was produced by our client, so he was cooperative with that procedure. He hadn't yet entered I guess if you consider the parking lot a part of the facility, but I don't think there was even an attempt to try to bring it into the building proper. And so with those facts in mind, I wouldn't have you find probable cause for count 4.
So I appreciate that argument, but I think we've had this discussion before.
I think so. I think we were talking about attempt or
Right.
Maybe when does the facility start? I think maybe was another discussion.
No, maybe, although I think the argument would probably be the parking facility counts, just like curtilage in a house. But the issue I'm stuck on is, in order to be introducing contraband into a facility, wouldn't he have had to have the intent to get arrested when he put the drugs or whatever the contraband is in his pockets? Which I don't think there's any evidence he intended to be arrested and then introduce it. What says the state?
Your Honor, my understanding regarding the intent element is if the officer tells them, we're gonna take you in, they're gonna find anything, do you have anything on you? And they say no, and then something is found later, then that is enough to show the intent that they knew that it potentially would be located and it would be later located. Given that it was in the parking facility, which is a part of the confined area of the BRC, it is locked and closed and only law enforcement has access to it. The public does not. State believes that it's still a part of the correctional facility as it is locked and not accessible to the public, only by law enforcement.
All right, so I pulled up the statute. It is unlawful, except through regular channels as duly authorized by the sheriff or officer in charge, to introduce into or possess upon the grounds, so I think you lose on that one, Mr. Brandt, of any county detention facility, or to give to or receive from any inmate of any such facility, wherever said inmate is located at the time, or to take or to attempt to take or send therefrom any of the following articles, any narcotic. So,
And Your Honor, as to what I think you're referring to, we did have case law, I believe, as to intent. And I think in the case law, the facts were he had a locket, or someone had a locket and that was inside the locket. And so the intent wasn't there because they didn't know, nor should they have known, I guess, that it was in the locket. If we're going to the intent element, I don't believe he had intent because he produced it for the officer.
I don't see where you're reading that the officer asked for it and handed it to him.
Well, I think there were two instances where, let me bring
They
it up.
found the suspected cocaine on him twice, once from a front pocket. The defendant said that he believed it to be crack cocaine, and then while inside the jail parking facility, the officer found another bag after he produced it from his pants pocket.
so where does it say that the officer asked him if he had anything else on him?
It doesn't, Your Honor. However, intent is a question for the jury. So at this time, I believe there's enough for PC that he possessed it on county detention facility grounds and property.
Yeah, I don't know. So it says to introduce into or possess upon the grounds. So
Would you be willing to meet in the middle, Your Honor, and just find PC for attempt?
I believe the statute covers attempt.
I think it does. I think that's part of it. Here's what I'm gonna do.
Your Honor,
Go ahead.
according to the jury instruction, to prove it, state must prove 3 elements. 1, that he had knowledge of the presence of the item. Arguably, I believe that is present here. 2, that he introduced the item into the county detention facility, possessed it on the grounds. And then there's some others about actually possessing with other inmates, but I believe possessing the item upon the grounds satisfies the second element according to the jury instruction. And then the third thing on the jury instruction is the item was a written communication, a recorded communication, currency, article, food, tobacco, cigarette, cigar, beverage, narcotic, controlled substance, firearm, etc. So the 3 elements is he had knowledge, he possessed it on the ground, and the item was a controlled substance.
Which jury instruction is this?
This is a jury instruction for
Give me the number.
the contraband, Florida statute 951.22,
No, give me the jury instruction number.
25.17.
That's it.
I can also print it for you if Your Honor would like to see it.
Wait, I couldn't hear anything you just said.
I can also print it if you cannot find it within your book.
No, it's in the book. I just didn't know which number it was. Okay, hold on.
2517.
Oh my goodness, I'm having the hardest time turning these pages today.
Would you like to see it? Tyler?
All right, here's what I'm gonna do. Mr. Brantz,
Yes, Your Honor.
if I were you, and I'm not, but if I were, I would do some research and bring this court some case law about this, because I seem to remember there's case law on point, but I keep forgetting to go pull it.
I understand, Your Honor, and I can produce it for the court if you wish to see it in second session, or we can just wait. I can have it ready for the next PC challenge on this charge.
Yeah, you can, and I mean, we're gonna take a break soon, and if you find it in the break, we can readdress this case, but for now, because I read the statute and it says either introduce into or possess upon, I am gonna find probable cause, but I'm gonna treat that as a subsidiary count and reduce that bond amount. Oh, it's already reduced, but I'm finding there's probable cause. Bond on count 3 is $5,000, each of the others will be $150. He's not allowed to possess a weapon, firearm, or ammunition, can't possess or consume any controlled substance, or have contact with any known drug dealers. But after the recess, if you've come up with something, we'll readdress the
I
case.
appreciate that, Your Honor. Thank you.
And just for my own knowledge, I need this for the next time we address this, because I remember that case law, but it's 15 years ago, so I'm assuming there's more updated case law.
I'll look, Your Honor.
Thank you.
Other, Chanel.
21 CF 12632, you're here charged with grand theft. There is probable cause. I'll appoint an attorney to represent you. Your bond is $1,000. You can have no contact with any witness or co-defendant in this case. You can't return to the scene for any reason. Good luck, ma'am.
Just Scott.
21 CF 2054, a capias was issued for your arrest for failing to appear on charge of possession of fentanyl. There's no bond. The PD was previously appointed. Good luck, sir.
Louis Vasquez, hospital.
All right, 21 CF 12638. Mr. Brantz, I'm going to appoint your office in this case.
We'll waive the appearance, Your Honor.
All right, there is probable cause here. Let me,
Your Honor, would you consider counts 2, 3, and 4 as subsidiary?
hold on, let me pull it up. What says the state?
I'll leave that within your discretion, Your Honor. I believe the controlled substances he had was all fentanyl. It's not like he possessed different controlled substances, so I'll leave that within your discretion.
All right, I'll do that then. Count 1, bond is $100,000. Counts 2, 3, and 4, it'll be $150,000. He's not allowed to possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers, and I'm revoking his bond in 21 CF 12242.
Ira Tatiana, she refused court.
21 CF 12620. I'll find her refusal a willing waiver of her appearance today. There is probable cause, and I'll appoint an attorney to represent her. Her bond will be $5,000 on count 1, $100 on 2 and 3. She cannot return to the scene. No contact with the co-defendant. And at this time, I'm revoking her bond in 21 MM 5465.
Robert Young,
21 CF 12584, you're here charged with battery with 2 prior batteries. I'm going to appoint an attorney to represent you in this case. There is probable cause here. Let me look. All right, sir, your bond on this is $2,000. You can have no contact with either victim or or any witness in the case. You can't possess a weapon of any kind, firearm, or ammunition. You can't return to the scene for any reason.
Your Honor, you downgraded it?
What was it?
It was 25.
Yes.
Okay.
But I show that he's on probation and a violent felony offender of special concern.
Yes.
So has there been a violation of probation warrant?
He has a via.
Hello, Cisco Unity connection.
Just kidding, we're trying to get the interpreter on the line. It's not 12.
Hello, Cisco.
Wow. We may not be able to start with him. I mean, we got to get him in before noon, but they're not answering. Let me try one more time, really fast, before we take him out. Can you guys bring him in again in like 10 minutes? All right, let's try that. Sorry.
Your Honor, can we readdress one from this morning as well?
Yes.
Mr. Guzman, which was 21 CF 4620. It was the indictment for the first-degree murder with a firearm.
All right.
I informed the court that we did file an information, and we charged second-degree murder with a firearm, also a life offense. You did hold him no bond. However, I've been informed that the second-degree charge is just the holding charge, and the indictment will supersede that information. Therefore, the bond should be for the indictment charge, which is that first-degree murder with a firearm. So we should have kept it first-degree murder and maintained the bond at no bond.
I didn't give him a bond though, right?
No, you had no bond, but.
But it is for first degree, not
It
second?
should be for first degree with a firearm instead of second with a firearm.
All right.
I just wanted to make sure the record was clear and the
Thank you.
minutes were clear.
Counselor, do you want us to bring your client back in and tell him that?
I don't see a reason to unless the bond's changed.
It is not.
He has our number, so we can go over the issue of the indictment versus the information with him in counsel. But unless the bond changed, I don't see a necessity.
He also has private counsel. He has Mr. Bono.
Hopefully his counsel will talk to him about.
Yeah, I'm not going to discharge the public defender at this time, but, all right, thank you. They don't? Oh. Okay.
The first one I have is Higginbotham.
20 CT 928. Mr. Brantz, your office already represents him on this?
We'll waive the appearance and enter a plea of not guilty on it.
Division 63, pretrial conference is October 28th at 1 PM, courtroom 12C.
When you say restricted movement, is that medical?
Yes.
Yeah, so who's this? What's your name?
David Dar, D-A-R.
20 MM 3914. You're here charged with petty theft. The PD has already been appointed to represent you.
We'll enter a plea of not guilty on it.
Division 81, pretrial conference is October 21st at 9 AM, courtroom 4E.
Good luck, sir. So does that mean we can't see him today? Oh, she. All right, we can readdress her at the end of the docket. Hello?
Hi, is Michael available?
So I don't know who you're looking for, but you've called a courtroom, and we're in session.
Oh, sorry about that. Thank you.
Thank you. How does that happen? Well, that was interesting. What's your name, sir?
Elijah Pompey.
2019 MM 809. Mr. Brantz, your office represents him in this VOP?
This is Mr. Pompey? Yes? As to,
Oh, he has two cases, 19 MM 8118. You represent him in that one as well.
as to MM 8118, we'll enter a plea of not guilty.
And as to the VOP?
And as to the VOP, we'll enter a denial, Your Honor.
To 8118, Division 80, pretrial conference will be October 21st at 9 a.m., courtroom 9C. And as to the VOP status will be October 4th at 9 a.m., courtroom 7C.
All right, good luck, sir.
Willis, his behavior.
21 MM 5784. Mr. Brantz, your office represents him as well.
We'll waive the appearance and enter a plea of not guilty, Your Honor.
Division 63, pretrial conference is October 28th at 1 p.m., courtroom 12C.
Who's next?
State your name.
Carlos Ars.
Hands down.
You're here in 21 MM 6679, charged with trespass on property after warning.
Your Honor,
There is probable cause. Go ahead.
there was an offer conveyed of a withhold credit time served and no return.
Your Honor, I did have a chance to speak with Mr. Ars about that state's offer, as also conveyed to him the plea form for him to review, and we went over some of the rights to be waived and the results of entering a plea today, and I still think he wishes to enter a plea.
Did you also discuss with him that he's out on bond on a violent offense and this court may still revoke that bond?
I did, Your Honor, and I was hoping you would take no action on that, as Mr. Arce is willing to resolve his current case today.
All right, raise your right hand, please.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, you had the opportunity to discuss with an attorney the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yes, ma'am.
Did you have a chance to review that form in front of you? It further explains those rights, the plea agreement.
Yes, ma'am.
Do you have any questions for me about the rights you'd be giving up?
No, ma'am.
You understand that if you're on probation anywhere, this plea can violate that?
Yes.
You understand if you're not a U.S. citizen, you could be deported?
Yes.
And as I just said, you are currently out on bond for charges of battery and disorderly conduct. At this time, the court has not made a decision as to whether I will revoke that bond. So you understand that even if you enter a plea today to this trespass, I may still revoke that bond and hold you at no bond. Do you understand that?
Yes, ma'am.
All right, sir, with all of that in mind, how do you wish to plead to the charge of trespass on property after warning?
No contest, ma'am.
I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the
1 day.
1 day that you've been in custody. I have to order that you pay court costs. I'll give you a year to pay those. I'll further order that you're not allowed to return to the Lynx bus station at North Garland Avenue. Do you understand?
Yes, ma'am.
And as to his out on bond case, he also has, other than the pending case, no criminal history, so I'd have you consider that in your determination as well.
So here's the court's concern, Mr. Brantz. While out on bond for a violent offense, battery, he's arrested for this trespass, and if you review the affidavit, it says that he was given verbal warnings. He was escorted off the property. He was continuing to make verbal threats. He returned minutes later, ignoring law enforcement's lawful commands that he leave. So I understand that the violence had not occurred, but threatening concerns this court when he's out on bond for a violent offense.
I understand the court's concern, Your Honor. If you're not inclined to take no action, I would just have you revoke and set at a higher monetary amount. If he's not out on a monetary amount already, just to set a monetary bond.
All right, give me one more moment. All right, sir, on the trespass charge, you have 30 days to appeal in writing. What says the state as to his out on bond?
Your Honor, I understand your concern regarding the threats made and given that he's out on bond for a battery case. In that case, I believe it was at Cowboys Orlando, and the defendant allegedly pushed an off-duty security officer in the bathroom. Before other staff was able to get in and assist the situation. So I'll leave it within your discretion, Your Honor. The battery it appears to be pushing a security officer 3 times in the bathroom before the security officer was able to get him to the ground. So while it is a violent offense, it's not the worst battery we've seen, so I'll leave it within your discretion.
All right, sir, at this time, I'll take no action on your out on bond case. Good luck. Yes, sir.
You ready for the interpreter?
We could try again.
Good morning, Your Honor. Jaime Sotomayor, certified federal interpreter, already sworn. 1 second while I connect to the headphone.
Thank you.
The interpreter is connected, Your Honor.
All right, thank you. Sir, please tell me your name.
Ángel Genaro Guillén. Ángel Genaro Guillén.
Angel Gennaro Guillén.
This is 21 MM 6667. Sir, you're here charged with trespass on property after warning. There is probable cause. Is there an offer in this case?
The state did convey an offer of an adjudication of guilt, credit time served, and no return to Lancaster Square Commons.
All right, Mr. Brands.
Déjeme explicarle un momentico. Eso no es una propiedad privada. Eso es el welfare, donde dan ayuda. Donde yo no fui ahí. Yo paso por el pasillo a la placita, donde venden comida. Compro una lata de frijoles.
Let me explain. Let me explain. That's not a private property. That's a place where there's the Wayfair, and I just go there to get my food. I go along a walkway, and I go and I buy a little can of food, and that's where I was stopped.
All right, sir. It sounds like you may have some defenses to this charge. You can enter a plea of not guilty today. I'll appoint an attorney to represent you, and you can have your attorney raise those defenses and perhaps convince the state to drop the charges or represent you at a jury trial. You can enter a plea of guilty or no contest to the charges, and I'll sentence you today.
Guilty for what?
Trespass on property after warning.
Que no penetré, yo paso por el portal a la placita a comer, a comprar comida. Esa es la oficina de ayuda al hombre.
I did not trespass. I just go along a walkway to a little plaza where they have the food. This is a place where they have an assistance office for people.
Your Honor, can we be appointed in this case?
Yes. All right, sir, I'm going to appoint the Public Defender's Office to represent you.
Your Honor, I don't want Mr. Gillen to take a plea to something he doesn't find himself guilty of. I would just have you set a bond in this. Would you consider ROR if he has an address that the court can communicate with him?
Did you say he does have an address?
I think
His paperwork says transient.
No, ahí me tienen viviendo. Yo estoy viviendo en la calle. Yo perdí.
I don't think he has an address, counselor.
Mr. Gillen.
Your Honor, I'm not objecting to you setting a lower bond.
I ask if he has a place where he gets mail.
Yes.
No, yo no tengo correo. Yo vivo en la calle. La policía me dejó omitir San Ley.
I don't have any mail. I don't get mail. I live out in the street. You know, the police just stop me whenever.
All right, here's what I'm going to do. I'm going to release him on his own recognizance. But sir, you can't return to this property, and you have to stay in touch with your attorney, because if you fail to appear for a court date, the judge can issue a warrant for your arrest and hold you at no bond. You understand?
¿Cuándo tengo que venir al tribunal?
So when do I have to come to court?
I don't have a court date for you. You're going to call that phone number, and your attorney is going to tell you when your court date is. Oh, it'll be on your paperwork. When you get released, you'll have your next court date. All right, good luck, sir.
Buena suerte, Estados Unidos.
Thank you for the interpreter services. I believe that's all we have.
You're welcome, Your Honor. I'm sorry, Your Honor, your name?
Gibson, Judge Gibson.
Gibson. Thank you.
Yes, sir. Thank you. Please tell me your name.
My name is Stephen Marcus Connell. I live at 5136 Nadine Street, Orlando, Florida.
Thank you. 21 MM 6668. You're here charged with resisting an officer without violence. Was there an offer?
Yes, Your Honor, the offer conveyed was an adjudication, credit time served.
Your Honor, can I have a moment to confirm?
Yes.
Your Honor, I would have you just set a bond. Would you consider ROR on this case?
Your Honor,
I'll consider it. What says the state?
State would object to an ROR, Your Honor, given the allegations in the affidavit that he became aggressive and wanted to fight the DCF investigator who arrived on scene, and then not listening to law enforcement. So between not listening to either of the two government employees, he also has a fairly lengthy history. I understand his last conviction was 2009, however, state would object, Your Honor.
Can he be screened for mental health pretrial release?
No, Your Honor, I think ROR is sufficient, as he takes care of his parents, he lives there with them, and he receives mail there as well. So he would get any summons from the court, and he would be working with our office to also attend any court dates.
Your Honor.
My concern, hold on. My concern is the allegations in the affidavit are, there was definitely a threat or a promise of violence. And I think that law enforcement was able to de-escalate it, but I'm concerned about the safety of the elderly parents, as well as honestly your client's safety, really. I want to make sure that
Your Honor.
he's safe.
Can I approach?
Yes. Just give us a minute, Mr. Cannell. Sorry. Rebecca, could he qualify for pretrial release?
Ma'am, I'd like to say one little thing.
Okay, before you do, let me make sure that you understand that everything you say is being recorded and can be used against you later.
Yes, ma'am.
You have an attorney standing next to you who's representing your interests.
Yes, ma'am.
Do you still want to say something?
Yes, ma'am.
All right, go
My
ahead.
family hired me to come here and take care of my parents. My mom had a stroke. My sister is real reputable, works for one of the biggest building companies in town. My brother has $1 million business. My other sister lives in Colorado, originally came to take care of her, and she went psycho and abandoned my parents. That's when they asked me to step in and pay me. I've been there 2 months before the pandemic. I took excellent care of my parents, 3 meals a day. It's a big 4-bedroom house. I had to start doing the lawn because they couldn't afford everything. I had to cut the cable and hook up all the antennas in the house so they had cable. I cleaned my parents, I bathe them, I clean the house. I do everything in that house and everything that 3 grown adults would do, including banking. They have turned over the durable power of attorney all to me. They told my brothers and sisters that I'm going to get the house because I have stuck it out and took care of them. I take care of my parents very good. And when those police showed up today, that my parents told them, Steve is a great caretaker. They weren't interested in that. They came up to me and they went like this, like a school child, boom, on my chest. I said, dude, what are you doing? Boom, and they were provoking me to do something. And I refused to do anything. And when I told them I was going to the mayor's office and internal affairs, that's when they arrested me. Because they knew they didn't want me going down there. I know Elaine Gonzalez works out of the mayor's office. I know all the police officers. I know all the Metro Bureau investigation guys. Believe me, I know everybody. And they didn't want me going down there because he screwed up when he got to come on my porch doing that because there's no law against speaking. And I have a right in my own property to speak my mind. And I didn't appreciate them coming up there bullying me. I've been under a tremendous amount of stress taking care of my parents. It's a lot of responsibility. And I've been there almost 3 years sticking it out with two parents that are practically bedridden, doing everything. I mean, talking medicine, appointments, food, taking care of the house, banking, everything you could think of, I have to do for them. Okay?
Well, I'm sure that they appreciate your help, sir, and I do understand that's stressful.
And that report that you're reading is totally false. I didn't want to fight with the guy who was here. What I told him is, listen, you can't just show up in my house and expect to barge in. My parents are elderly and they're sick. My mom's resting. My dad's all stressed out. He's got late-stage Parkinson's. He's 91. He can't even get out of bed barely, except to stand on the side and pee and get back in bed. And you don't need to barge into our home and invade our home. Make an appointment and you come right in.
All right, so Mr. Cannell,
Yes.
it sounds like you think you have some defenses to this. I think you need to speak to an attorney about those,
Got one right here.
right? But we're not having an evidentiary hearing here today.
But I'm just saying, that report you're reading is false. I'm a good guy. I haven't been in any trouble in 15 years. I pay my child support every month. I pay my child support and my bills on time, and I've been in an outstanding system for 15 months. You can look at my record, and I've kept everything up, my driver's license, everything. And that's not living at my parents'. That was on my own, 11 years away from my parents, because I was there before taking care of my parents. And I decided that wasn't what I wanted to do. I wanted to go back to Ocala and start my business. But when my mom had a stroke, she couldn't do it on her own, and I had to come back.
Well, what I'm going to do today is I'm going to place you on pretrial release.
Okay.
So you will be released today.
Thank you.
But here are the conditions, Mr. Cannell. You have to cooperate with DCF investigators.
Listen, I want to say one more thing. They came over to my house before, right?
Okay.
And they put my mom under emergency, because my mom needed to go, hold on, let me say it, because it's true, and I didn't do anything. It was a false report. And they came back, and they wrote me a thing saying that it was false. Saying, Steve, you didn't do nothing, we're sorry. There's no process on it. They've been harassing me.
So they have a job to do.
I know they do, and I would let them in. I told them I would
Okay,
let them in.
good, because I'm ordering that you have to comply with DCF.
Okay.
But you will still be released today. You can't possess a weapon, firearm, or ammunition,
That's anything.
and I'm going to allow you to return to the home.
Yeah.
So I hope that everything you're saying is true, and please take good care of your parents.
And I asked the police officer that brought me here, I said, am I gonna be able to, he goes, oh, yeah, you can go back.
All right, good luck, sir.
Thank you.
Please tell me your name.
Anthony Corso.
21MM6671, you're here charged with petty theft. 6672, 73, and 74. All of them are retail petty theft. I'm assuming there's not an offer in these cases today?
There's not, Your Honor.
All right, I'm going to appoint an attorney in each of these cases. Your bond will be $500 in each case. You cannot return to the scene of any of the crimes, and you cannot have contact with any witnesses in the case. Do you understand?
Yeah, so am I being charged with something?
So you were arrested for retail petty theft, and there is probable cause for each of those charges.
Okay.
It doesn't mean the state's going to prosecute it. I don't know if they will. The state has to make a decision.
Okay, because I've been here for like 30 days and I just don't know really what's going on with all this. That's all.
So it's 4 different cases charging you with petty theft.
Your Honor, he's, I believe, in custody for other cases, and then these were added on.
Oh, I see.
Are we,
They're alleged to have occurred in August.
Can I take a plea deal today for these? Because
You cannot. The state doesn't have an offer, and at this time, I'm not going to accept an open plea to the bench on this on these charges. So you just need to stay in touch with your attorney's office.
all right, who's my attorney for this?
So the public defender's office, you call that number, and they'll tell you who's assigned to your case. I don't assign the attorneys. Good luck. Please tell me your name.
Felicia Davis.
21MM6669. You're here charged with trespass on property after warning. There is probable cause. Was there an offer?
No, Your Honor. This is the same location for the case that she's out on bond for. It's also the same location for the case that she pled to in February of 2021.
All right, ma'am.
we do have comp concerns as well, Your Honor. Consider that as part of your ruling.
I'm going to reduce your bond amount to $200 with a special condition that you cannot return to the Dollar General at 928 South Ivy Lane. Do you understand that?
Yes, ma'am.
I'm appointing an attorney to represent you, but I am going to revoke your bond in 21MM720. So you need to stay in touch with your attorney.
Would you consider setting just a higher monetary bond?
I'm not going to at this time. Please tell me your name.
Xavier Puckering.
21MM6675. You're here charged with trespass on property after warning and resisting an officer without violence. There is probable cause. Was there an offer in this one?
Yes, Your Honor. State conveyed an offer of an adjudication of credit time served and no return to the food lotto.
I did have a chance to speak with Mr. Puckering, but would you give me a moment to confer?
Yes.
Thank you. Thank you, Your Honor. I did give him the state's offer as well as a plea form to review before court, and I believe he still wishes to enter a plea today.
Please raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can put your hand down. You had the opportunity to speak to an attorney about the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yes, ma'am.
Did you review that plea form?
Yes, ma'am.
All right, after reviewing that, do you have any questions for me about the rights you'll be giving up?
No, ma'am.
You looked hesitant. Now's your chance to ask questions if you have them.
I just,
I mean, I don't know what to say really. This is my first time in here. So.
Hold on, yeah, I need you to get closer to the microphone.
I said I don't know what to say really. This is my first time, like my first in big boy jail. So I don't know what to say really. I just want to go home. That's it.
Well, so I want to make sure you understand, though. You have the right to remain silent, the right to a jury trial when one is required, the right to call witnesses and present any defenses you may have. You also have the right to testify on your own behalf. You have the right to force the state to prove the charges against you at a jury trial if one is required. You're giving up all those rights today if you enter a plea of guilty or no contest. Do you understand?
Yes, ma'am.
If you enter a plea of guilty, you're telling the court that you're guilty of what the state has charged you with. If you enter a plea of no contest, you're telling the court that you're not admitting guilt, but you think it's in your best interest to enter a plea. I'll treat it the same as a guilty plea, and I'll sentence you today. You understand that?
No, I don't.
No. So a plea of guilty admits that you did what the state accused you of doing. You're admitting you're guilty. A plea of no contest says you think it's in your best interest to enter this plea, but you're not admitting guilt. But I'm going to treat it just like a guilty plea and sentence you today. So if you plead guilty or no contest, you'll be sentenced today. If you plead not guilty, I'll appoint an attorney to represent you and will continue your case to be heard at a later date by a different judge. So if you think you have some defenses you want to raise, if you want to force the state to prove it at a jury trial, all of those things happen later, not today.
I could take no contest.
You can. That's up to you. You don't have to.
I'll take just no contest, ma'am.
What did you say your last name is?
Puckering.
All right. I show that you have an extensive criminal history.
Yeah, that's when I was in juvenile.
Okay. You understand if you're not a U.S. citizen, you can be deported?
Yes, ma'am.
And if you're on probation anywhere, this plea can violate that probation?
Yes, ma'am.
You also understand that if you want to enter a plea of not guilty, I'll appoint an attorney to represent you. I'll give you bond and bond conditions, and you can bond out. So you don't have to enter a plea of no contest today. You understand that?
Speak what?
Yes, you can discuss with him.
I mean, Your Honor, he qualifies for pretrial release. You just want to give him pretrial release.
All right, you also qualify for pretrial release.
Your Honor, he seems really unsure. Can you just set a bond or pretrial release? It seems like he has multiple questions for an attorney that may be better heard at a later time when the attorney has longer to speak to him.
Your Honor, I think he wishes to resolve it today with a plea of no contest. That's my understanding after speaking with him.
Does this qualify for any of the pretrial diversion programs the state has?
It potentially could, Your Honor, but given his history, I don't know if he would.
All right. All right, so Mr. Puckering, what is it you want to do here today?
Resolve the case, no contest.
I'm sorry, one more time?
Said, resolve the case, no contest.
All right, so you want to enter a plea of no contest.
Yes, ma'am.
And you understand all the rights you're giving up by doing this.
Yes, ma'am.
Do you have any other questions for me about these rights?
No, ma'am. But can I ask you about pretrial release?
So if you enter a plea, the case is over and I'll sentence you today. If you want to be placed on pretrial release and further discuss with an attorney, I will do that.
No, ma'am. Just
But that does not resolve the case today.
go ahead. We're resolving the case, ma'am.
And you understand that when we say resolve the case, what that means is I'm going to sentence you today and you will have a criminal conviction on your record for trespass on property after warning and resisting an officer without violence.
Yes, ma'am. And I have a question.
Yes.
With those two charges, how long do they stay?
Forever. You're an adult now, so these charges will stay on your record forever.
And I have another question. So me trying to get a job, like, cause with construction, my uncle he do construction. So would that kind of affect me if I would try to work with them?
I don't know the answer to that. These are misdemeanor charges.
I don't know too much. I just,
All right, Mr. Puckrin, I can't give you legal advice, but I'm concerned with accepting a plea from you today because I don't want you to lose sight of what you're giving up to enter a plea, because you said you just want to get out today. But this has consequences with it. And I want to make sure that you understand those and have adequate time to talk to an attorney about all of your options. So how about this? How about I appoint the public defender's office, they're going to enter a plea of not guilty on your behalf, and I release you on pretrial release. How does that sound?
No objection, Your Honor.
All right, that's what I'm going to do, sir, with just the special condition that you can't return to this scene. Do you understand that?
I can't return to Full Auto. That's what
Correct.
you're saying? Okay.
At 2060 Americana Boulevard. Don't go back there.
I hear you.
And stay in touch with your attorney, okay? It won't be him, but call the number on that green piece of paper. They'll tell you what attorney is assigned to your case.
Okay.
Okay?
Thank you.
Yes, sir. Good luck.
Ricardo Villanueva Jr.
21 MM 6678, you're charged with resisting without violence. Is there an offer in this case?
No, Your Honor.
All right, I'm going to appoint the public defender's office to represent you. There is probable cause. Your bond is $1,000. You can't return to, what was he at?
It was Colonial Drive in Lexington Street. Your
All right, I'm
Honor.
not going to say that. All right, good luck, sir. Okay. Yeah, it's an intersection.
Robert Allen Scott, second.
21 MM 6677. Sir, you're here charged with stalking and trespass in a structure or conveyance. I'm going to appoint an attorney to represent you in this case. There is probable cause here. Your bond is $1,000 on count one, $100 on count two. You cannot return to the Family Dollar at 2641 North Hiawassee Road. You cannot have any contact with a victim in this case or any witness. And you can't possess a weapon, firearm, or ammunition. Do you understand?
Ma'am.
All right, good luck, sir.
Stevens, bonded.
Okay.
Evan Malaire.
21 CT 6410. Hold on. Evan Malaire. You're here charged with DUI, driving under the influence. I'm going to appoint an attorney to represent you in this case. There is probable cause here. Your bond is $1,000. You can't possess or consume any controlled substance without a valid prescription or any alcoholic beverages. You'll be subject to random drug and alcohol screens, and you can't drive without a valid Florida license. Do you understand?
Yes, ma'am.
All right, good luck, sir.
Who else you have, Your Honor?
I have Stephanie Ansbro.
Bonded.
I have
Francois,
Marvell Lowe.
bonded.
Dan Nguyen.
Bonded.
And then I have something that looks odd. Alexander Valentine. I don't know what this is.
Bonded.
All right. And then we have Shaquandi Lockhart. Please tell me your name.
Wanda Deshay Lockhart.
21MM213. You're here charged with petty theft. I'm going to appoint your office, Mr. Brands.
Thank you, Your Honor. We'll enter a plea of not guilty.
Division 80, pretrial conference is October 21st at 9 a.m., courtroom 9C.
Good luck, ma'am.
What's the bond amount on that case?
I don't have it because it's an arraignment. Do you guys have it?
She's not at the jail on it, Your Honor, right now. She's been revoked on a burg dwelling. So she's not in custody on this case.
But there still should be a bond amount on it, whether she can get out or not.
I don't see her in here on this case.
Yeah, she's not.
Right, but usually what happens, even if it's an NTA, I guess there wouldn't be a bond amount on it. Was it an NTA? So because she's here on a no bond on something else and she's not in custody on this, there's no bond amount, but she can just leave on this. But it's the other charges that are holding her, so she can't bond out because she has a no bond.
I don't see an information filed.
When did I get?
When did they file on this, Your Honor? She's asking.
She just said there's not been an information filed yet.
Yeah, because I never even had no petty theft charge before, ever.
It doesn't say that you did. It just says, it just has it listed as a single petty theft.
Aren't you arraigned when you're filed on?
It was.
No.
It was a direct information, Your Honor, filed from a misdemeanor non-arrest case.
So it was filed.
It was filed on 9/17.
So it was filed September 17th. That's when it was filed.
You should call us, okay?
All right, good luck, ma'am. Anything else before court is adjourned?
Nothing from the state, Your Honor.
I'm from the defense side.
All right.